Thanks for joining us this afternoon for the next CYCJ webinar in the course of our series. Today's webinar is from Dr Delmage. He's going to be talking about the minimum age of criminal responsibility and where that takes us in the future, looking at the international comparisons of what has been various different nations' approaches to minimum age of criminal responsibility. Ennis is an adolescent forensic psychologist, a senior lecturer based in University in Wellington, but originally from the UK, and thankfully the way things have worked out in terms of time zones, he's in the UK just now, hence you not all having to be up at 3 o'clock in the morning to hear him speak live. But I'm sure that Ennis will happy to answer any questions as we go along, or rather at the end of the presentation, so please do use the chat function for any questions or comments or reflections that you want to make. It's been recorded, this webinar, and will be made available to everybody who signed up for it at a later date. And during the course of the conversation, Sally and I might be dropping some messages into the chat regarding links to relevant materials and so on. But with that, I'll pass you over to Ennis, and thanks again, Ennis, for giving up your time, and looking forward to your presentation.
Oh, thanks very much, Ross. And I think it sort of goes without saying that I'm very grateful to have this opportunity to talk about a subject which has been a sort of passion of mine for most of my career. I'm actually a psychiatrist, not a psychologist, and there are groups of psychiatrists and psychologists who get very offended if you mislabel them. I'm not one of those people. I'm very honoured to be promoted to psychologist, but I'm actually a jobbing psychiatrist, and I work in an inpatient unit called Ngātaiohi, which is a secure adolescent forensic mental health unit in New Zealand. It's actually the secure one. There isn't another one because New Zealand's really small. So about 6 million of us, and yeah, very grateful to be here to talk to you. I did promise Ross that I would wear a bowler hat for this presentation, but packing constraints meant that wasn't possible. But I did wear my favourite Tool t-shirt, who are indisputably the greatest band in the world. So hopefully you'll feel sufficiently flattered. So I'm going to talk about the minimum age of criminal responsibility, and Ross and I and a few other people were involved in a research project looking at where the minimum age was set internationally. And I'm really trying hard to write a book and failing miserably to do so far. It's a fascinating subject, and the more that I got into it, the more fascinating it became. I look at Scotland with green eyes of envy at the moment, given that in New Zealand our minimum age is still 10. Hopefully my slides are transitioning. I did do a presentation a while ago where I got to the end and everyone said, oh, they're very nice, but none of your slides moved from the first one. And I thought, well, I wish you'd told me that at the beginning. Anyway, for the purposes of today, what I'd like you to do as audience members, and please do send stuff through in the chat, I'd be really interested to hear people's views on this, is I want you to imagine that you discovered a new country and you need to set a minimum age of criminal responsibility for this country. So here it is, a glorious picture. In the middle there, the sort of sunny region, that's a fairly affluent city, and on the west it's a bit like the Lake District, I suppose, lots of lakes and a bit mountainous, and in the north you've got a sort of snowy alpine region. This isn't a map of New Zealand, by the way, in case anyone's wondering. This is a map of Elden Ring, which is a very famous, extremely challenging video game, which I've had the displeasure and trauma of playing. So any nerds in the audience may have spotted that. So here you are, you've discovered this country and you need to have a think about where you're going to set your minimum age of criminal responsibility. I take it everyone understands what I'm talking about. The minimum age is the lowest age at which a child can be prosecuted and taken through a court process. Children can be arrested at any age, by the way. If the police spot a child, you know, that's in trouble or doing something they shouldn't be doing, they can grab hold of them and take them somewhere, usually a place of safety. But in terms of the minimum age, this will be the point at which they can be deemed culpable and prosecuted. So have a think about your country and where you're going to set your age. But because I'm feeling charitable, I'm going to help you a little in your journey. So there are some things which you might be influenced by when deciding where to set your minimum age. You might want to think about the international scientific research. So, you know, what do we know about brain development and how might that influence us in terms of where we're going to set our age? You might want to think about legal research. There's lots of interesting case studies out there, and there's some interesting case law that comes through from time to time, so that might influence you. You might want to dive into the annals of criminology. You might want to become a bit of a sociologist and think about society's need to punish and all those good things. You might want to think about what the United Nations say on this. So this is the Convention on the Rights of the Child. They have a general committee which periodically makes statements about where that minimum age should be set. So these are all things that might influence your thinking. But you may also want to consider the history of your own country and who you've been colonized by, and you might want to just copy and paste their laws. You might want to think about the history of other countries. You might be triggered by high-profile cases. So these very much hit the public consciousness. I don't know if anyone saw the Netflix series Adolescence. I suspect most of us probably did, and found it compelling viewing. So that might influence where you want to set your minimum age. I got into a Facebook argument, which you should never do, of course, about the point of the Adolescence series. And a lot of people were saying, oh, you know, the dads, you know, there was intergenerational violence, and you know, the mum was a bit passive, and I thought, but to me, the point of it was they were just a fairly ordinary family, you know, not perfect, not terrible, just sort of fairly ordinary, but there was a big pile on, and I stopped commenting eventually. Anyway, high profile cases may influence your thinking in terms of where you want to set your minimum age. You might want to rely on national crime surveys. They're not always that reliable. They often are going up when actual crime is going down, but that might influence where you want to set your minimum age. You might want to think a bit like a politician and think, well, you know, being tough on crime is usually a vote winner, so perhaps that's the way we want to go. You might want to think about how affluent your country is. Unless you're Jeff Bezos, you'll have some financial constraints in terms of what you can do. And you might want to think about the media. And again, politicians living in the real world, of course, have to deal with this interface with the media fairly regularly, and be cautious about how they're being perceived. So the colours I've used there are not by mistake. Clearly, the left-hand side is what I think we probably should be influenced by, but on the right-hand side is what we're often actually influenced by. So hopefully this has helped you a little bit on your journey as to where you're going to land, and we'll see how you get on. Before that, though, I guess there's a question about whether you should even have a minimum age of criminal responsibility. Does it even make sense? If you look at civil positions, we tend to use Gillick competence. People have probably come across this term. So as children get older, they acquire capacities and capabilities to make certain decisions, and that's not linear. So some develop it younger, some develop it older. So from a civil law position, we're fairly flexible, and we try to accommodate the fact that children develop at different rates, and that age isn't always an arbiter for maturity. So you could say, well, do we even need to have one at all? One way of doing it would be to say, well, we're just going to look at each individual child, and some of them may be very competent, very mature for their age. Some of them may be less competent, less able to get involved in moral reasoning and make sensible judgments. So we're just going to do it on a case-by-case basis. That would be an acceptable way of thinking. Some places don't have one. So France would be an example. The majority of the states in the US don't have a minimum age. They often rely on the federal position. Yeah, so you could go for that and say, I don't want one at all. We're just going to do it all case by case. If you're not going to base it on age, what could you base it on, which is less arbitrary? So if you're going to find a child culpable, legally culpable for their actions, what could you base that decision on, which is less arbitrary than age? Well, you could use height if you want. So the taller the child, the more criminally responsible they are. It might not be that different to using age in some senses. However, what I would suggest to you is, without having one, how do you stop weirdness happening? And one weird example would be a conviction of a 6-year-old. And if you think I'm joking, North Carolina, until a few years ago, their minimum age of criminal responsibility was 6. So there are perverse things that do happen. And for this reason, the UN advise against not having a minimum age of criminal responsibility. They say, look, it's best to draw a line. We get that there's some flexibility in terms of development, but you still need a hard line to say it is perverse to criminalize children under this level. Okay, so what did I spend a bit of time doing over the past few years? Well, we did a study involving 14 countries in the end, and we compared their position, where they set their minimum age. We thought a bit about the history of those countries, and we thought about the variations of interest within those countries. And then, of course, we had to chop most of that out because the article ended up being 20,000 words. We started off with this, and this is the culmination of about 10 years of hard labor on my behalf, where I was translating Swahili penal code and trying to understand not only Swahili, but also the legal terms, which are almost like a foreign language to me. So I produced this sort of dog's breakfast of a map here, which shows you where the minimum age is set all around the globe. And one thing which I hope is fairly apparent quite quickly is that there isn't really a consistent theme. There are some countries where the minimum age is hard to understand as to how they'd arrived at that position. Russia, for instance, not a country synonymous with human rights records, are fairly protective of their children and set their age at 14. We have Brazil with their age set at 18. Yeah, fairly hard to discern an obvious pattern there. There are definitely some colonization effects. So you can see in countries that have been colonized either by Britain or France that they've often just copied and pasted the penal code. But yeah, a bit of a mess. Not North Carolina, that set their age at 6. You'll be relieved to hear they raised it to 7. Much more sensible. So I really worked hard to try and keep this map as up to date as possible, but things change quite quickly. So again, triggered by some high profile cases, China, that previously set their age at 14, has now dropped their age down to 12 for high profile offences. And Australia, we had a moment where things were looking positive, and the Northern Territory raised their age to 12. Then a new political leader came in who was on the right, and she said, no, we're lowering it back down to 10 again. The Australian Capital Territory, which unfortunately is too small to be seen on this map, have raised their age to 12. And whilst writing this, between that time and me talking to you today, Victoria have raised their age to 12, which is right down on the bottom of the map, just above Tasmania there, which is exciting. And they're planning to raise it to 14, I think, in July this year. So make of that map what you will. I found it fairly fascinating when I was putting it together, and even continents like Africa, there's just quite a wide variation in terms of where that minimum age is set. The most common age internationally is 14. So if you want to find the most frequent age that's set, it is 14 around the globe, which coincidentally is where the UN General Committee recommends the age be set. The picture is even more complicated, unfortunately, for you as audience members. So not only do we have this image, which has the minimum ages set out, we also have this thing called Doli Incapax. And Doli Incapax is a protection for children, usually between the ages of 10 and 14, something like that. And Doli Incapax runs that if the child didn't understand that what they were doing was seriously wrong, then they can be acquitted, and it's a presumption. So the presumption is that all children in that 10 to 14 year age group are Doli Incapax until the prosecution prove different. So the burden is on the prosecution to prove, no, this child did know what they were doing was wrong, and they can be convicted. So DOLA Incapax or an analogue of it exists in quite a number of countries internationally. The literal translation would be incapable of evil. And as I said, it's a rebuttable presumption above the minimum age. If you're below that age, so in Scotland, for instance, if you're below the age of 12, we have what's called a conclusive presumption. And that means no child can ever be prosecuted in that group, no matter what the prosecution put forward, no matter what evidence comes forward from school or teachers or family or social workers or whoever. There could never be a prosecution. So it's a conclusive presumption, but it is rebuttable above that minimum age. So for that 10 to 14-year-old group, usually there's a presumption that they're DOLA Incapax until the prosecution prove otherwise. In order to be DOLA Capax, or to be convictable, if you like, they must know that the act or omission was seriously wrong, and seriously wrong has got a legal definition behind it. It's very poorly tested in the UK, which I think probably used it a fair bit. The prosecution would often rely on teachers, social workers, sometimes the child's own parents, to find evidence that they actually did know that what they were doing was seriously wrong. And it wasn't run that frequently, and when it was run, it was often unsuccessful. It's very old as well. How old is it, you say? Well, the first written account we found, or the first account that it had been used was from 886 AD, although good old Aristotle had alluded to this idea that children should have a level of moral reasoning to be convicted back in 340 BC, but it's a very old doctrine. This is the first written definition that we had from 1619, and it runs as follows. An infant of 8 years of age or above may commit homicide and shall be hanged for it, if it may appear that he had knowledge of good and evil. These aren't spelling mistakes, by the way. This is how they used to write things in the olden days. And of the peril and danger of that offence. But an infant of such tender years as that he hath no discretion or intelligence, if he kill a man, that is no felony in him. So if anyone's really interested in the history, do get in touch with me afterwards. I've got a whole raft of really interesting stuff about how these laws arose. But that's the first written definition that we had, and it really hasn't evolved very much since that time. So as a child forensic psychiatrist, one might wonder, is there a better way to describe this notion of developmental immaturity than using this DOLA Incapax doctrine, which is really old? And I would say, yes, there is a better way of describing developmental immaturity, and that term is developmental immaturity. So this first appeared in a UK Law Commission paper, really brilliant piece of work. I don't know if people have read many of these special issue or special reports that the Law Commission produced, but really well evidenced and very, very carefully thought out. And the Law Commission felt that there should be a defence, a partial defence of not guilty by reason of developmental immaturity. And this is separate to a mental disorder, right? So most of the work that I do, I'm dealing with insanity and those kind of defences. And for that group, you've got to have a mental impairment, mental disorder, brain abnormality, these kind of things. But developmental immaturity is not an abnormality. We've all been developmentally immature at one stage or other. Some of us still are. So this is a natural part of our development and warranted a completely separate defence. So the Law Commission suggested this back in 2013, and it didn't go anywhere, unfortunately. But it was a very well written piece of work, and I've held on to it because I think that notion of flexibility around developmental markers is really important. So the weirdness doesn't stop with DOLA Incapax, unfortunately. 66 out of the 200 and something odd countries around the world do have DOLA Incapax or an analogue of it. There are 9 countries with different minimum ages for boys versus girls, and shocker, girls get a worse deal than boys, sometimes by the matter of 5 or 6 years. So girls are deemed culpable at a much younger age than boys are. And there are 5 countries where you've got Sharia law operating alongside state mandated or federal law, and it just depends on where you were born and what your local court is, kind of thing. And in Gaza, you've got multiple different legal processes, including tribal adjudication, military law, and some law set by precedent and common law principles. There were 5 countries where I just couldn't establish a position. There was no penal code available, if it even existed. They were usually little tiny Pacific Island countries, which I feel I should get a grant to go and visit, so I can really dig into what the minimum age should be. Yeah. Now, 26 countries do vary the minimum age according to the seriousness of the offence. And one example would be Ireland, and another would be New Zealand, where I'm working and living. So these countries would say, well, look, if it's a very serious offence, so in New Zealand, that would be murder, manslaughter. In Ireland, it would be murder, manslaughter, arson, rape and sexual offences. If it's a very serious offence, you can be culpable at a younger age. So we would say 10 or 11. But if it's a less serious offence, the age would start at 12. And as I mentioned, there are 13 countries without a minimum age set, including the majority of the US. The US is endlessly fascinating for a whole range of reasons. One being that they're not a signatory to the UNCRC. They're the only country, in fact, that isn't a signatory. It's the most ratified international instrument that we've got legally. But the US has refused to sign up to it. I think on the basis that they feel their constitution is an adequate protection for them. However, what that did mean is that they were still putting children on death row until 2005. It was only a case. I forget the name of the case, but anyway, in 2005 they stopped putting children on death row, and in fact until 2008, and that was Graham versus Sullivan, you could get a whole life sentence as a child. Whole life meaning you're going to die in prison. There's no chance of parole. You'll never be released. So eventually the Supreme Court took a look at this in 2008 and said, well, this is cruel and unusual punishment. To tell a 14-year-old that you will die in prison is fairly unconscionable. So they eventually got around to banning that as well. But one might suggest the UNCRC would have helped them probably 70 years ago with that issue. So here are the countries that do that stratification by offence type. So the more serious the offence, the lower the age is. And as you can see, New Zealand and the Republic of Ireland, or just Ireland, are in that group. I couldn't make much sense of this group. I think, Ross, we were thinking maybe we could have a bit of research as to what the commonalities might be between these places, but yeah, they're an interesting grab bag. There are some arguments for this, by the way, to say that, you know, either the sort of length of sentence or the seriousness of the offence should arbitrate. And funnily enough, there are some arguments around gender as well. And whilst you might think, well, it's horrific that girls are culpable at a younger age, the brain development folks would say, well, look, girls are more mature than boys at a younger age. They've got more sophisticated brain architecture. This isn't conjecture. This is, you know, there's lots of research out there to show that. And so maybe they should be deemed more culpable at a younger age. All of these things should be helping you with your consideration as to where you're going to set your minimum age. So the problem, I think, is that, again, there's no consistency within these countries or between these countries. So the types of events that are deemed serious do vary a lot. And some will say, well, we'll stratify based on seriousness. This would be, you know, the nature of the offence itself. Others will vary on the length of the sentence that would be a result. So New Zealand would be an example of that. For the 12 and 13-year-olds, we vary on sentence length. The UN are not a fan of stratification, by the way. They're not a fan of differentiating based on gender. They're not a fan of Doli Incapax. They don't feel that should be in there either. And they're not a fan of stratification based on the seriousness of the offence, and indicate that perverse things happen in court if you do this. Yeah, they talk about discriminatory practices creeping into the courtroom as a result of these vagaries. So here's the outcome of our 14-country study. There's a fairly cold-looking downtown Helsinki. Finland have a welfare-based approach for kids below the age of 15, and you can still be required to pay compensation, or your family can be required to pay it for offending behaviour below the age of 15. And they also have a DOLA Incapax analogue for the 15 to 18-year-olds if the act is due to what they describe as thoughtlessness or imprudence rather than being heedless of the prohibitions and commands of law. The mentality in terms of children and probably adults as well who commit offences is really interesting. So when you look at the law, an awful lot of it talks about morality, moral reasoning, moral judgment. You know, insanity has often got the word impaired moral reasoning in there somewhere. And I'm 49 now, and as I'm getting sort of older and working with more and more of these children over my career, the arbiter really, when they're actually committing offences, I think is more emotional resilience. It's more whether they've got the capacity to inhibit their impulse than whether they're making a moral judgment about the rightness or wrongness of the offence. And I say that in part because quite a number of the kids can be fairly moral if you sit down with them when they're calm and not on drugs and not under conditions of extreme duress. They can make fairly moral judgments. But in the circumstances of the offence, I don't think that moral reasoning is really creeping in there. I think it's, you know, there's a really high limbic system impulse which is driving them, and there's probably a bit of peer pressure in there as well. And they do things which are fairly monstrous and would not be their normal modus operandi. So whilst countries are very fascinated by knowing right from wrong and morality and moral development, I'm getting more and more interested in emotional resilience and emotional control, really. Anyway, so in Finland, you do have some mediation options for lesser offences. It's quite diversionary, and children that are detained are mostly detained in secure welfare settings. There are some prisons that have a sort of youth unit, if you like, for young people available. So Sweden, there's the Northern Lights, not the best lights, by the way. That's Aurora Australis down where I live, but you know, good effort, Sweden, anyway. So Sweden used to stratify for serious offences from 14, but they ditched that in 1902. It has a fairly odd status. So the under 15s technically can be capable of committing crimes, but cannot be sentenced to a criminal sanction. So you could almost argue that that is a lower minimum age than it appears. But because there is no criminal outcome and because they don't go through a criminal court, I think the more sort of what we call family courts, the UN view their age as being 15, but it's a strange position. Oh, look at that. Bucolic, lovely, idyllic Scotland. So Scotland previously did have their age set at 8 since 1937. And as you know, I kind of feel like Scotland and New Zealand should be siblings, really. Most child offending's been dealt with in a fairly diversionary way via children's hearings where possible. And as you educated folks will know, the age of prosecution was raised from 8 to 12 in 2011, and then subsequently raised, the criminal responsibility age was raised to 12 in 2019. I know that there are efforts afoot to continue raising, as is also happening in the Australian Capital Territory. And Ross helpfully pointed me towards this monitoring process of the outcomes over a 3-year period. So I'll talk a bit more about Scotland in a second. Here's lovely Copenhagen, freezing cold as well, but very pretty. That's an expensive night out, Ross, I will tell you. So Denmark, there've been some efforts to introduce sanctions from the age of 10 from a fairly right-wing government, which is now in place. And the other thing that Denmark did is they created these youth crime boards. Again, this is a right-wing government, and that they were very heavily criticised as a sort of workaround for where the minimum age was set. For children aged 15 to 17, they do still have the advantage of more leniency around sentencing and some diversion into child welfare settings, but there is a bit of a creep into a more kind of punitive approach. So youth crime boards also exist in Denmark and can produce a kind of plan of improvement. So in New Zealand, we have family group conferences, and they'll also they have a plan which is an inherent part of that process, which the young person would sign up to. England and Wales, here's central London, obviously. So in England and Wales, it was aged 8 up until 1963. And then a subsequent Children and Young Persons Act indicated that it would be raised to 14. And this wasn't, it could be, it will be raised to 14 in the statute in 1969, but that was never delivered for various kind of political change reasons, and also the case of Mary Bell, which was around that same time as well. As you'll be aware, public opinion in England and Wales was very heavily shaped by some high-profile cases, and unfortunately continues to be so assailed. So that's the Thompson and Venables case in 1993. The case went to court, and Mary Bell, who people may remember was a 10-year-old who, with a 14-year-old girl with an intellectual disability by the name of Norma Bell, not related, killed two toddlers via strangulation in the 70s. So the media made these cases very high profile, especially the Thompson and Venables case, where the two children were named. And that's really kind of hamstrung efforts. So the Maggie Atkinson, the then Children's Commissioner in 2010, published an article making the case that the age should be raised, and the press had a bit of a field day really and brought out Denise Bulger, the mother of James Bulger, the toddler that was murdered by Thompson and Venables, and she was vilified really for suggesting it should be raised. There have been a number of private members' bills, so there's a few of the Lords that are fairly supportive of the cause, but they tend to sort of die as they move through the parliamentary process. I think one of the problems for us as scientists, clinicians, researchers is that we're talking in 20 to 40 year timescales in terms of outcomes, whereas that's not much use to a politician who's thinking about the next election cycle and wants something very visible that they can produce. Anyway, moving on to Northern Ireland, this is Giant's Causeway. In 2011, there was a review conducted saying that the minimum age should be raised from 10 to 12 and then on to 14. And the Justice Minister actually a year later made a commitment to raise it, but again, it sort of died in the Stormont executive. There was a public consultation in 2022 with fairly strong support, but again, no progress as yet, and it's still set at 10. Here we have Dublin, where I was a week ago, very pretty. In Ireland, set at 10 or 10 for serious offences, but for those 10 and 11-year-olds, as I said, you can only be deemed culpable for very serious offences. They closed their young offender institution in 2017. These places are beset by scandal, as you're probably well aware, and Australia and New Zealand are not immune to that either. We've had a fair share of horrific incidents, scandals, riots, children on roofs, suicides, and those sorts of things. So luckily they closed theirs in 2017, and children now would go to Oberstown House Detention Centre, which is a fairly welfare orientated rehab kind of setting, or at least on paper it is. So the Netherlands, I'm probably offending a whole group of people with these stereotypical images, but there you go, tulips and windmills. So the Netherlands, 16 to 18-year-olds can still be sentenced through adult law processes, although that's fairly rare. And there was an interesting act on adolescent criminal law, which is flexible and works up to 23, which is a very forward-thinking way of looking at adolescence as we would define it. we had some of these people presenting in Dublin, and we got very confused because they were talking about adolescents, but what they meant was 18 to 23-year-olds in their research study. And yeah, so they have a different way of looking at things. Again, in the Netherlands, there are some efforts to raise to 14, but there's a lack of political will so to do at the moment. Here we are in the Louvre in France. So no minimum age. They rely on what they call discernment, which is kind of Doli Incapax by another name. And this is a sine qua non. So you've got to have this discernment ability to understand your offence and its consequences in order to be convicted. Again, I've made an argument about emotional resilience being a more important factor, and I'm happy to have that debate with anyone that's up for it. Although there is technically no minimum age, there is a general presumption that those under 13 would lack this discernment. And France has 6 specialised penal establishments for children, or they may go to these separate remand sections of adult prisons under certain circumstances. And they also have these 52 closed educational centres. So our French colleagues will talk about education being at the heart of the rehabilitation process. So they rely quite heavily on these education centres for most children. It's only if the risk was very high would they go to the penal establishments. Here we are in Portugal. This is Lisbon, where I went on my honeymoon. I don't know who that's not my wife. I don't know who that woman is in the picture, but yeah, Lisbon, very pretty. So in Portugal, they have a very heavy education and supportive measures for those under the minimum age 12 to 16. And these 12 to 16-year-olds can be subjected to what they call educational guardianship, which essentially adds support in the community. There was a proposal to reduce it to 14, but that got rejected in 2006. And for under 12-year-olds, there's only child protection measures which can be used. And however, the bad news is if you're 16 or over, you're mostly at the mercy of adult courts at that point. And India, the Taj Mahal there. So the lowest age in our study set at 7, but there is a Doli Incapax protection for those aged 7 to 12. And this is how they define it. They say the child must have sufficient maturity of understanding to judge the nature and consequences of their conduct on that occasion. The other bad news in India is that the age of majority, so this is the point at which the child could be prosecuted as an adult, was lowered from 18 to 17. Most countries it's 18, but in India they lowered it to 17 after a very high-profile rape and murder case for a woman called Jyoti Singh. There were a number of people at that point crying for the death penalty for that 17-year-old as well. He was part of a bigger group of people that were also convicted, and the adults were sentenced to death. So it was lowered to 17, despite that being contrary to India's own constitution. But there you go. And since 2016, children committing serious offences can be moved to adult justice systems. And here's Australia. So you may be wondering, which picture have I chosen for Australia? Well, let me introduce you to a quokka. So if you're ever in Western Australia, in Perth, take the ferry from Fremantle out to Little Rottnest Island, and you find these little fellas. And this isn't Photoshop. This is exactly what they look like. They're incredible, and they've no natural predators, so they just come running up to you, very friendly. So in Australia, there was a discussion that almost on a federal level amongst the attorneys general, which was due to happen in 2023. I don't know if that did happen or not, but anyway, there's not been any progress about raising the national position to 12. But Australia, kind of similar to America, has got lots of different states and territories, and they all do things slightly differently. It was raised to 12 in the Northern Territory for a brief period, but the Chief Minister lowered it to 10. As I mentioned, it is now 12 in Victoria, with plans to raise to 14. In 2027, my mistake. And there have been previous efforts to raise it in New South Wales, so it's currently 12 in New South Wales, in the Australian Capital Territory, and there's some hope around Queensland. So here's the Iguazu Falls in Argentina, very beautiful. Our colleague in Argentina said, oh yeah, I feel very embarrassed because our age is 16, whereas in Brazil it's 18. And I thought, oh crikey, I wish I'd had that problem. So in Argentina, if you're under 16, you might get a formal record, which can be taken into consideration if you commit another crime when you're 16 or over, but they're fairly protective of their under 16s. And those that are 16 to 18 can only be prosecuted if the offence would normally result in being locked up for more than 2 years, and it's been that way since 1980. Current government, people are aware, is extremely right wing and may change things, but no change as yet. And last but not least, the very beautiful Aotearoa, New Zealand, the land of the long white cloud. And there in the background, you can see Mount Cook, which is 16,000 feet. And again, not Photoshop, the water really does look like that. So come and visit, lovely. In New Zealand, it was set at 7 in the 18th century with a Dola Incapax analogue. And there have been various efforts to make the case for a raise. It's now at 10, including a big effort from Amnesty International and various other groups of us, including our College of Psychiatrists, but there's no shift from 10. And the current government, being a sort of right-wing coalition, is unlikely to support a raise. They've built military-style academies or opened them as part of a wing of another unit, which are boot camps by another name. They have 3 strikes rules and a young serious offender category, which is very hard to get off of. So things are not in a good place in New Zealand at the moment in terms of the justice system anyway. Okay, so back to me being charitable and trying to help you decide where you're going to set your minimum age. I thought I'd try and do an economic analysis for you. So you're thinking about your country's GDP, and I'll try and help you out. Unfortunately, ChatGPT came up with nothing. So the research really hasn't been done in terms of the financial pros and cons. Or at least it hasn't been done until very recently. For obvious reasons, the calculation of the direct costs is difficult. The calculation of the indirect costs is incredibly challenging to work out, and you need a very long time scale to really work out whether it's financially sensible to set your age higher or lower. However, I've had a bash at it because, again, I was feeling very kind. So the direct costs, if you're going to have, for instance, a very low minimum age, well, you're going to have to build secure institutions. You're going to have to staff them. You're going to have to manage them. As I've mentioned, these units are beset by scandal and challenges. You're going to have more youth courts if you have a low age. So if you set yours at 7, for instance, you're probably going to need to have a more rapid process and a higher number of youth courts. There'll be legal costs within all of this. Lawyers don't come cheaply, nor do judges. And there are policing costs, of course, because the police have to go out and interview these children and prosecute them. So the indirect costs are, well, you're at risk of criminalizing your young people and giving them an antisocial identity. And I'm sort of fairly big fan of labeling theory and the message that society is giving to these children. So you've got to be fairly mindful of that. You also risk perpetuating institutional racism and risking international condemnation by having a very low age. The UN are fairly critical where they do their reviews. And again, what we do know from the research is that there's a fairly poor economic outcome for those that have got a criminal history from a young age. Now, there are confounding factors within that, but there probably is a good argument for trying something slightly different. More crime, of course, means more victims, and that's also an expensive process in supporting them through the criminal justice system. What if you decide to set it very high? So if you think, well, I'm going to copy Brazil and set mine at 18, what are the costs of having a very high minimum age? Well, the direct costs are you're probably going to need an expanded welfare system. You're probably going to need more governance, and you're probably going to have to think about the costs of that. Most of the time, welfare settings are more expensive than corrections. You're probably going to need more family courts and more civil routes. There will be legal costs within that. And it places a higher workload on ancillary services such as me in health and my teacher colleagues in education. The indirect costs are burnout of welfare staff. So these are some extremely challenging and hard to reach kids, and that places a burden on that group, and potentially an added burden on families. If you're saying, well, we're not going to just take them away and lock them up for 12 months, you're actually going to have to help us to manage this situation. Other considerations, well, where you have a high minimum age, it tends to be a very welfare-based approach. This is the international reflection, is that most countries, then it's led by welfare, and then health and education, and NGOs will sort of tag on around that. The problem with having a welfare-based approach is that if you're taken to a locked welfare institution as a result of your behaviour, there isn't always an obvious right of appeal, and this is something that plagued America in the 60s and 70s, and their solution was to build lots of young offender institutions rather than building in an appeal process, which would have been my suggestion. It may also give victims and wider society a sense that the child somehow got away with it. You're removing personal autonomy and perhaps the child's sense of accountability. Having a low minimum age, a more youth justice system based approach, well, you do run the risk of damaging societal attitudes to teenagers and our sense of who we are. You have a heavy impact on the child's identity and their relationship with those in positions of authority, and as I mentioned, that perpetuation of societal racist attitudes. So all of these things hopefully will help you on your journey to decide where you're going to set it. So England is a real case study in the effects of penal populism and these high-profile cases, and this is the very famous picture of John Venables and Robert Thompson. The then Home Secretary Jack Straw illegally increased their sentence as part of a result of public sentiment. So the Sun had coupons you could cut out demanding a whole life sentence for these kids. There was about 23,000 coupons were sent in. And Rupert Murdoch's press did no favours to those of us working in this field and described these children as monsters, freaks, animals and evil. These were all headlines in the daily newspapers at the time. And the judge himself used the term cunning, said these two children were very wicked and had committed an act of unparalleled evil and barbarity. And I've really struggled with the word evil over the years in terms of understanding what it means on an absolute level, and how you then relate that to children who've often been through their own evils themselves and are often very traumatized. The word that really stuck out, though, there was cunning. So these were two 10-year-olds, and cunning to me implies a degree of executive functioning, forward planning, which really wasn't apparent in their movements on the day. So some interesting terminology coming to us from the judges. So poor old England stuck in a very old-fashioned way of thinking. This is a famous quote from Albert Camus, who said, to assert that man must be absolutely cut off from society because he is absolutely evil amounts to saying that society is absolutely good, and no one in his right mind will believe this today. So there you go. England wasn't always this way, though. So this was a case from 1861 of a boy called George Burgess, who was a 2.5-year-old child who was murdered by two 8-year-old boys, and the minimum age was set at 8 at that point. There was some media coverage of it, as you can read here. And he was in not dissimilar circumstances to the fate of James Bulger, was tortured and killed in Stockport, eventually drowned. There was a high degree of press interest initially, and this is a clipping of a news article from the time. But by the time the case actually came to trial, the press opinion was much more optimistic and talked about rehabilitation. And the two boys were found guilty of manslaughter and spent a month in jail and 5 years in reformatory, which is a shorter sentence than either Thompson or Venables got over a century later. And the judge in this case, in contrast to the Thompson and Venables case, described the two boys as having been involved in mere babyish mischief. So a very different perspective. So Denmark. Denmark did lower their minimum age from 15 to 14 in 2010 under a degree of political pressure from the right-wing opposition at the time. And the negative impact was fairly profound, and it was raised to 15 again in 2012, happily. And there's been research since then showing bad education and economic outcomes for children that were caught up in that lowering. Since then, the opposition have tried to lower it to 12, but it's been unsuccessful. And that evaluation, that evidence has been really useful, and we've used that same evidence to try to persuade politicians since then. So what happened in lovely Scotland? Well, you'll all be pleased to know it did not sink into the sea when the minimum age was raised to 12. And here's an excerpt from the report from the Age of Criminal Responsibility Advisory Group, looking at the outcomes, and you can read it there. The evidence that exists suggests that the age of criminal responsibility in Scotland could be raised to 16 with actually minimal impact on prosecutorial or court services, although the impact on other services would have to be taken into consideration. The report also recommended media guidelines to support public education, which really, again, is fairly key. It's what our colleges should be involved in helping the public understand the issues here. So I had to think about my own country and looked at the number of 10 and 11-year-olds in New Zealand since 1950, when this law was enacted, who'd been taken through the court for murder and manslaughter. Anyone got any guesses as to how many children have been through court, High Court, for murder, manslaughter, 10 or 11-year-olds since that time? Zero, so it's never happened. Easily, arguably, we could raise our age to 12 overnight. It would make no difference whatsoever. These children would still be under the remit of welfare services. And the number of 12 and 13-year-olds each year is about 30. So again, very small numbers. Sure, if you raise from 14 to 18, you're going to have a much larger number in that group. But actually, for under 14s, these kinds of crimes are fairly rare. I will just say, when we were talking about racism, Maori children aged 10 to 13 who offend are 3 times more likely to have proceedings against them than Pakeha, what we call white children, aged 10 to 13 who offend. What happens under the minimum age? UNICEF anticipates these children will be dealt with via welfare systems. This is what tends to happen. And children exploited by adults, this is always the question of what happens if you've got an older guy who's manipulating a child to commit offences. So that the UN's position is these children should be seen as victims, not offenders. The UN states that those under the minimum age should not be deprived of their liberty, and you need a good and responsive referral system between the police and welfare. And they also focus on decent in-depth reports from experts for the family court, and emphasise investigative interviews with the police. For those under the minimum age internationally, generally the UN recommend focusing on the best interest of the child, thinking about their right to life, survival and development, thinking about their right to express their views and the right to periodic review of their placement, and a very family orientated and community-based local interventions are recommended. And they talk about relying on mentoring and treatment of comorbidity, things that have actually got evidence base behind them. So here is a program in North Macedonia. There's a beautiful picture of the bridge there, which has a 5 life skills program, which talks about communication and friendship, employment, comprehensive sexual education, and emotions and self-respect, and relationships. And there's a couple of peer mentoring programs which are noteworthy, but this, from what I'd found, was a sort of utopia in terms of a welfare-based approach. And there are abuse and addiction programs available for those children as well, and a heavy emphasis on parenting skills. One final emphasis I will make, although we've got 5 minutes left, but it is a really drive for focus on citizenship. So these children often don't feel they belong to society. They don't have a pro-social identity. And Schneider has talked about citizenship as a really effective deterrent for against future offending. So in summary, our setting of the minimum age has rarely been decided by science, but that is changing. And these penal populism approaches do remain a problem for us. As I said, 14 is the most common age around the globe. We, as clinicians, researchers, scientists, do have a responsibility, I feel, to make the case to politicians. And the Raise the Age campaigns internationally have made a difference. Here's a good example in Australia. So I'm curious as to where the audience has landed in terms of where you would set your minimum age. There are multiple factors which influence it. Sadly, not usually fact, but that is shifting. And again, we talked about the colonisation effect. So people may have got different views in terms of whether they prefer a welfare-based approach or a criminal justice approach. Most countries around the world do have a welfare system of some description, albeit sometimes underfunded. My personal appeal is that mental health services really need to have a greater role in deciding on these types of legislation, given the really high rates of neurodiversity and other types of mental disorder, brain injury, speech and language problems within this group. We don't have any new resources, of course, there's no hidden pot of money, but it is a financially good investment for politicians given the lifetime costs. So over to you, folks. What approach should be adopted for children below and above the minimum age? Where are you going to set it? And most importantly, I think this is the conversation we have most frequently with politicians is what are you interested in the outcome being? If you're genuinely interested in reducing recidivism, arguably the approach of having giant young offender institutions and locking children up for long periods has failed. So something different seems to be called for. So my last take-home slide for you, do not give up. You too can defeat seemingly impossible odds. And there's a final slide of Elden Ring. My wife tells me off for the amount of time I play on it, but I went to the Writers' Museum in Dublin instead of going to the keynote speech. I thought it'd be a more useful way of spending my time. And there was a great quote in there from George Bernard Shaw saying, we don't give up playing because we get old. We get old because we give up playing. So on that note, I will stop showing my slides. I'm happy to field any questions that people might have.
That's great, Ennis. Thank you. Excuse me. Thank you very much for taking the time away from your computer for a short period of time, computer games rather, for a short period of time to sit in front of a computer and talk to us about ACR. I've been taking loads of notes there about Argentina and Denmark and North Macedonia. I think that really speaks to what's going on in Scotland and something we could maybe learn. I was wondering, just out of curiosity, if you feel you're able to and you want to, could you type in the chat, everybody that's still here, given what Ennis has said about this new country that we've discovered, what age do you think the age of criminal responsibility should be on that new country that Ennis or you have discovered? Few 16s, few 18s, 17, or 21 from Tristan. And whilst that's filtering in, Tristan, Ennis, maybe go back to a comment that somebody left. It was from Shona. She was mentioned, sorry, it was the wrong question. It was from Tristan Middleton again. Thank you very much for your interesting presentation. I agree with the consideration regarding emotional regulation. And they have asked whether or not psychological, I would add psychological consideration of understanding of consequence, future thinking and locus of control, in addition to those additional considerations that you'd highlighted. Any reflections on that comment from Tristan?
Yeah, I mean, I think what tends to happen when I speak to adult forensic psychiatrists is they say, oh, well, there's lots of factors that go into criminal behaviour and there's lots of considerations. And I do agree with that. You know, I think, you know, previous experiences of violence and, you know, things like peer pressure, education, you know, family circumstances, all of those are relevant. But I suppose the weight which we've historically placed on emotional control is I think probably inadequate and probably slightly skewed to all those other factors. And in fact, at that conference in Dublin I was at recently, there was a brilliant piece of research showing just that when expert witnesses interview these children, what they tend to focus on is all the other stuff, and they don't zero in quite as much on self-control. I mean, I think we wrote an article a while ago about deterrence, and it came from an appeal court case where they were looking at the you know, whether lengthier sentences or harsher sentences were a deterrent effect on children, and not only did they not seem to be a deterrent in children, they also didn't seem to be a deterrent in adults. And I think partly driven by the fact that most kids don't know what length of sentence they're likely to receive, so the sort of harshness of the outcome probably isn't a consideration. And in fact, what tends to influence children most is what they call celerity. So this is the speed at which they're likely to get caught. So if you really want to reduce crime, increase the number of police on the beat, you know, having harsher and harsher sentences is probably not the way of doing it. So a really interesting point. And as I said, the degree to which I think there's a rational thought process, a weighing up of pros and cons that goes on in the heads of these children when they're about to commit offences, I think we are overestimating the abilities of children to be making those kind of complex moral judgments in conditions of, as I said, usually extreme excitement, extreme duress, often influenced by drugs and so forth. So I would argue that we probably should try and shift our thinking a little bit and place more weight on that emotional resilience. And yeah, I think, we're not tripping over expert witnesses. There's only a limited number of psychiatrists and psychologists out there to do these reports. But there are some places like South Africa, for instance, where they've mandated that psychiatrists and psychologists have to be involved when commenting on things like doula packs or, criminal judgment in that way. So we have got some precedent, I think, to say that that's a really important consideration and should be given more weight. Yeah.
Yes. I'm going to keep two more questions, then I'm going to summarise what our future CYCJ webinars are going to be. So please stay on the line, because I know you want to have a teaser, a trailer of what's to come after the summer holiday. So I'm going to take a question from Sam Burns and then Susan McVie. But first of all, from Samantha Burns, or Sam Burns from Manchester City of Youth Studies. She's asking about how useful you think the role of psychiatry is in responding to children who come into conflict with the law. Bear in mind the risk of pathologising their behaviours, which in turn, and perhaps their lack of self-control, which is a response to their economic inequality and injustice that they're facing.
Yeah, it's a very good question. I mean, I've strayed very much into tiger country, really, in that I've started to think about the law more and more, and I'm not a lawyer. What I think we tend to rely on our brave psychologists who are usually more comfortable in making general statements for those without mental disorders, whereas my remit is usually to stick to those with mental disorders. Nevertheless, I think, when you look at these advocacy groups, they're a really lovely grab bag of people from all different professions who all bring their own specific expertise. And I think the extent to which I can comment on brain development, most of the research I rely on, by the way, is done by psychologists and not psychiatrists, but we at least have got a fairly thorough way of looking at the research and bringing that forward. I think we've all probably got a role to play. And the fact is that if you look at children that offend, almost all of them have got some form of mental disorder. The most frequent one would probably be conduct disorder, but rates of intellectual disability 50% in young offender institutions, rates of ADHD 40%. These are children with multiple comorbidities. Most of the inpatients in my unit have got 5-6 different diagnoses, including brain injury, and these children are extremely hazard prone in addition to being vulnerable to abuse and trauma. So I think, as I said right at the start there, Ross, I'd probably move away from saying this is a discipline-specific thing and saying actually we've all got some expertise, whether you're, a jobbing youth justice social worker, or you're a youth justice liaison nurse, or whether you're a psychiatrist or a psychologist or a teacher. We've all got useful things to say in terms of informing this debate, and it really needs that very general approach rather than making it one particular person.
As in Scotland, we had a policy document called "It's Everybody's Job to Make Sure I'm All Right," which I think is kind of what you're alluding to there. And the final comment, or question rather, is from Professor Sue McVie at the University of Edinburgh. She writes that her colleague, Leslie MACR, and herself had argued that raising the minimum age is only one step in a whole range of other things that need to be put in place. Political punitivism can be countered by evidence, and she poses the question, do we lack global evidence about what works when it comes to reducing youth crime and preventing recidivism?
Yeah, I mean, I suppose there's a couple of bits there. I definitely think that that research needs to continue in terms of what works. I mean, I guess we've looked at countries like Brazil and places where the minimum age is set quite high. The challenges, Ross, when you look at these countries, is it's very hard to compare. You often find that you're comparing apples with oranges in terms of a whole range of infrastructure which differs. Nevertheless, I do think there are some countries which are mostly comparable where the raises have happened, and as I said, these services haven't dropped into the sea. I will make the point again, though, that I think a raise to 14 statistically, or in terms of numbers that you're going to get through the court process, is a very different prospect from raising, say, from 14 to 16. I think there you probably need some heavy infrastructure investment. I mean, I think in terms of what works for whom, I do think that evidence is out there. So, you know, we're certainly aware that these are a very expensive group to get wrong. So, if you know, Stephen Scott's work for the 10 to 28-year-old children with conduct disorder versus those without show that they've got a 10 times greater costs to society. And, you know, the costs of getting it wrong are very obvious. We know that bit, you know. You know that these are extremely expensive situations if you don't get it right. You know, and I think there's probably a number of sociologists and criminologists that might comment on that issue of citizenship. You know, what tends to happen in New Zealand is that the children are often moved quite far away from their home area. And in order to rehabilitate them and, you know, build those links back, it's an extremely complicated process. Even for me in hospital, you know, these children are far away from all the local links. We don't know what NGOs are available locally. There may be some great charities. So it just makes that process much more difficult. And what, you know, seems intuitive would be more local, smaller, more local services where you can keep those links with family, you can keep those links with agencies. It just makes those transitions much more easy. You know, for the last 25 years, I've been doing transitions very badly. And I think all of us in psychiatry and mental health in general have been doing transitions very badly. We need to get a lot better at that, you know, those steps into moving from one service to another. Kids get lost to follow it so easily. So, yeah, I think, you know, that there are probably bits of evidence that we can rely on. And I think this is one of those real benefits to those group advocacy efforts, is that you suddenly find people bringing evidence from lots of different arenas that you weren't previously aware of. And it's a really joyful process to get involved in if you can do. I'm very lucky to have had a few brushes with that myself. So, yeah, big fan of it.
Thank you, Ennis, again for your time taken away to present to us today. And as you can see, people have hanged on beyond the 1 o'clock finish time to hear your answers and so on. Ennis's presentation will be sent out to everybody registered, a PDF version of the slides and a edited recording. Can I just please keep in touch. I'm sure Ennis will be welcoming any emails or any questions or comments from everybody in attendance. So after the summer break, we've got a number of other webinars coming up. We've got a webinar regarding the experiences of Black boys within the criminal justice system. We've got another webinar about boys engaging in harmful sexual behaviour. And we've also got a webinar by Dr Nina Vaswani here at CYCJ about the mental health of young men in the criminal justice system. So I kind of focus on the boys coming up over the autumn. But if there's anybody on the call just now who'd be interested in presenting a webinar, please do get in touch. And keep in touch with us at CYCJ using the link that Sally has just put in the chat, where your ability to sign up for any of those webinars can be met there. So thanks again for everybody for coming along, and hope you have a nice summer. Thank you.